Good evening, everyone. A warm welcome to all the participants and esteemed guests. On behalf of IPNet North Region, I am delighted to extend a heartfelt welcome to each one of you to today's webinar titled Cross Border Insolvency in India, Current Practices and the Way Forward. We are deeply honored to have with us our esteemed Chief Guest, retired Justice Mr. S.B. Gautam, former NCLT member, and our distinguished lead speaker, Dr. Risham Garg. Your presence today is invaluable and enriches this event significantly. As many of you know, this webinar is a part of series organized periodically under the auspices of IPNet, the National Network for Insolvency Professionals. Today's session is being hosted by IPNet North and is aimed at fostering insights and discussions on these critical topics. I would request Mr. Parag Singhal, General Secretary IPNet, to play IPNet introduction slide and website promo slide.
In the fast-evolving world of insolvency and bankruptcy, professionals need more than just knowledge. They need a strong network, continuous support, and a unified voice. As the challenges of the insolvency profession grow, so does the need for a platform where professionals can come together, share their experiences, and find collective solutions. That's why IPNet was formed. Promoted by Transition, IPNet is more than just a network. It's a mission to unite insolvency professionals across India, empowering them with the tools, knowledge, strong leadership, and community support they need to excel. Our purpose is simple: to create a cohesive community of insolvency professionals that stands strong together, advocates for their interests, and drives excellence in every aspect of the profession. At IPNet, we believe in continuous learning and collaboration. Our activities are designed to ensure that every member stays ahead in their field, from specialized study groups that dive deep into critical topics like CIRP, compliances, and many more, to webinars and workshops that bring the latest insights right to your screen. IPNet is your gateway to professional growth. Backed by Transition, a leader in insolvency training and resources, IPNet is committed to promoting the interests of insolvency professionals. Our goal is to ensure that every IP, no matter where they are, has access to the best resources, strong leadership, and a network that truly understands their needs. Join us in this mission to build a stronger, smarter, and more connected community of insolvency professionals. Together, we can overcome challenges, shape the future of the profession, and make a lasting impact. IPNet, National Network for Insolvency Professionals in India.
Thank you, Mr. Parag. Now I would request our fellow IP, Mr. Sandeep. Thank you, Mr. Parag. I hope it's over now. So I will ask our fellow IP, Mr. Sandeep Chitkara, to introduce our chief guest, retired Justice Shri S.B. Gautam, former NCLT member, and speaker of the day, Dr. Risham Garg.
Okay. Yeah, good evening to all. It's my utmost pleasure to announce the august presence of Shri Shyam Babu Gupta, who has served as Honorable Technical Member of NCLT Mumbai Bench. So, regarding his qualifications, he did his LLB from Delhi University and did his LLM from Mewar University, Chittorgarh, Rajasthan. So, here I would like to inform my colleagues in brief about the illustrious career of Shri Shyam Babu Gautam. Actually, he started his journey in the year 1984 So after his enrollment with the Bar Council of India and practiced as an advocate at the Delhi High Court and Supreme Court, specializing in corporate laws and taxation. From year 1989 to 1995, he joined the Ministry of Law and Justice as Assistant Legal Advisor, Indian Legal Service, UPSC cadre. In 1995 onwards, he joined the Ministry of Corporate Affairs as Assistant Official Liquidator, Indian Corporate Law Services, and worked in various roles over there. 2014 onwards, he was appointed as Director, Inspection and Investigation under the Ministry of Corporate Affairs. Thereafter, in 2016, he was appointed as Regional Director, Southern Region, Chennai. And continuing with the same, in 2018, he was appointed as Director General Inspection and Investigation under the Ministry of Corporate Affairs. Finally, in the year 2019, he was appointed as technical member in NCLT Mumbai bench on 19th of June 2019, and he retired from this very post thereafter. So I would like to mention here some of his special achievements, which are to his credit as of now. He has received a letter of appreciation from Honorable Member Shri Sachin Pilot, the Minister of State. He has delivered many lectures on topics such as mergers, demergers, amalgamation, and the process of registration of the companies. He was co-chairman of the drafting committee for the rules and amendments under the Companies Act. So this was his illustrious career. Overall, his detailed profile reflects a distinguished career with various roles in the Ministry of Corporate Affairs and his extensive experience in corporate laws. So this is all. I now it is over to Madam Tina.
Yeah, I would request our IPNet North Head, Mr. Vikram, to welcome our chief guest.
Thank you, Tina. So I'm delighted to have you all today on this 13th webinar being conducted by IPNet on the topic cross-border insolvency, current practices, and way forward. It is an honor to have with us today retired Justice Mr. S.B. Gautam, former member NCLT, as our distinguished and esteemed chief guest, and Dr. Risham Garg, our distinguished keynote speaker on the topic of cross-border insolvency, current practices, and way forward. So IPNet is a dedicated platform for insolvency professionals. It is, actually helping the IPs in expanding their knowledge and resolving their queries on a day-to-day. So it's a dedicated platform which helps the IP to resolve their queries as and when the practicing IPs come across. The IPNet platform is unique because, it gives you a dedicated login ID, a dedicated membership number, and by virtue of your login, you can access to immense valuable resources, which is available on the website of IPNet. And you can join dedicated study groups as insolvency professionals to various study groups being organized by IPNet. I'm also, like to convey my special thanks to our colleague IP Rajiv Agarwal for extending a lot of support in organizing these webinars. So I welcome you all, and I look forward to a very insightful and very interactive session today on this very important topic. Now I would, request Tina to welcome our chief guest to deliver his lecture.
Respected SB Gautam sir, we would request you to give us your valuable insights and valuable knowledge, and share it us whatever you want to share with us as a IP. Thank you.
It is now my turn.
Yes, sir.
Sir, it's our pleasure to listen to you, sir. We are all
to
eagerly waiting.
Good evening to everyone. I am honored to deliver the keynote address on the topic cross-border insolvency in India, current practices and the way forward. I would like to extend my gratitude to the IPNet team for organizing this wonderful insight webinar and providing a platform for insolvency professionals to discuss and deliberate on critical issues shaping the future of our field. In fact, what is cross-border insolvency? In IBC, there is a two section, 234 and 235. 234 enables India to enter into bilateral agreement with other countries for cross-border insolvency cooperation. And 235 empowers the NCLT to issue letters of request to foreign court for assistance. In fact, the very first case, it was in Jet Airways, which was decided by the NCLT Mumbai bench. How this case has germinated actually, a petition was filed. Three petitions were filed. Three petitions were filed against Jet Airways.
Mr. Mahamay, please switch off.
It is all right.
Yes, sir, please continue.
We will give a brief actually facts of the Jet Airways, how this case has come up before the Mumbai bench. Three petitions were filed against Jet Airways, the corporate debtor in this case, for initiation of corporate insolvency resolution process against it for the huge outstanding debt owed. During the first hearing, the NCLT bench was apprised of the fact that insolvency proceedings against the Jet Airways has already been begun prior month in the district courts of Netherlands. The bench in this regard opined that conducting a concurrent proceeding in the same matter would cause delay and vitiate the proceedings in the case. The reasoning put forth was that of two sections, 234 and 235, as I have quoted earlier, for recognizing the order of a foreign jurisdiction, mandates the requirement of the Indian government to have reciprocal arrangement with the foreign country. However, the court noted that in the instant case there was no reciprocal arrangement between the Dutch government and the Indian government. So this bench took this aspect taken into consideration by the NCLT bench Mumbai, and they were aware that the registered office of the Jet Airways was in Mumbai, that is in India actually. So, and their primary assets were also located in India. Most of the business they were operating in India actually, but certain business they were doing in other foreign countries, offshore businesses also. Therefore, the NCLT had the requisite jurisdiction in the instant matter. The bench, by its order dated 20th June 2019, set aside the proceeding of the Dutch court and declared as a nullity. The initiation of the corporate insolvency resolution process in India against Jet Airways was accepted by the NCLT. Now the CIRP has been admitted and the proceeding has been started actually. This order was challenged before the NCLT Delhi by the Dutch trustee. The NCLAT also considered the appeal and directed the resolution professional appointed on behalf of the Jet Airways to consider the feasibility of having a joint corporate insolvency resolution process. The RP, along with the Dutch trustee, reached to an agreement for facilitating the resolution process through a proposed cooperation model. Both the parties reached a final agreement on the proposed model and submitted to the NCLT for approval. The NCLT accepted the model by its order dated 26 September. The bench also allowed the Dutch court administration to attend the meeting of Jet Airways. So with this process actually, the government the Dutch government and the IP appointed by the Mumbai bench, they were able to collect the assets and to realize the debts of the corporate debtor company. Thereafter, you know the story. The plan was presented. Plan has also been approved. So this way, that is the small. This is highlights of the case actually. In the actually, while this delivering the judgment, actually there is a judicial innovation. In the absence of the comprehensive framework, Indian courts have taken innovative approach to cross-border cases. We have referred one case, this Jet Airways already we have referred. Another case is this Videocon also. Because in Videocon actually the number of companies were ordered to be put under CIRP. There were the assets of the companies were in foreign country. And the third one case is also the order passed by the Chandigarh bench in the matter of SEL manufacturing. Is CD undergoing insolvency proceeding in India was able to access the assets in USA due to the cooperation extended to the RP by the US bankruptcy court. Actually, in fact, the cross-border insolvency in India, we are trying to make a law actually, but still we know things are not made live, but it is in the process. The committee was also appointed, headed by our ex-secretary Injeti Srinivasa. He has submitted a draft report also. He has also rules has also been for framing of the rules. Another committee, Dr. K.P. Krishnan committee was formed. They have also submitted their draft rule. So this is all pending before the government actually. In fact, there is a need actually because unless the universal model to address the challenges, at least 54 countries they have adopted this universal model on cross-border insolvency. The framework provides standard mechanism for handling insolvency cases involving multiple jurisdictions. The key principles of the model includes recognition of foreign proceedings, country classify proceedings as main and non-main, depending on the company's center for main interest, that is called COMI, popularly known as. Then cooperation among courts. It facilitates direct communication and cooperation between domestic and foreign courts. Fair treatment of creditor. Ensure equitable treatment of domestic and foreign creditors. Relief of foreign representative. Allow representative of foreign insolvency proceeding to participate in domestic cases. Countries that had adopted this model have reported greater efficiency and predictability in handling cross-border insolvency. Why India should adopt model law? What is the need? India has already drafted, as I have already told, India has already drafted a framework to adopt the unilateral model law, and doing so would bring significant benefits. Predictability for foreign investors. A standardized framework would give foreign creditors confidence in India insolvency system, encouraging investment, assets recovery across border. Recognizing foreign insolvency proceeding would make it easier to recover assets located abroad, as seen in Videocon we have referred, where group insolvency face difficulty due to jurisdictional fragmentation. Alignment with global standard. Adoption would again align India's insolvency law with global best practices, reinforcing its image as a business-friendly jurisdiction. Improved efficiency. A clear framework reduces delay and cost in resolving cross-border cases. So this is the actually reason we should adopt this. Now, what are the key challenges and their solutions? Harmonizing with domestic laws, integrating the model law with the existing provisions of the IBC and other Indian laws will require careful legislative planning, judicial coordination. Effective implementation will depend on the cooperation between the Indian and foreign courts. Clear guidelines and training program can help achieve this. Capacity building, judges, insolvency practitioners, regulators must be trained to handle these complexities of cross-border insolvency issues effectively. Stakeholders involvement, involving foreign creditors, global investors, and domestic stakeholders in consultation will ensure the framework address practical concerns. So these are the few aspects actually which will smoothen the process. Here we highlight one case of Jet Airways. We have already highlighted actually. Briefly, we have already said. Now we have also actually we are going through the reports of the chairman IBBI. He has also in his note actually the proposed framework will govern the application seeking recognition of foreign insolvency proceeding as well as application from foreign jurisdiction seeking cooperation in Indian proceeding and imparting addition to recommendation made by ILC, Insolvency Law Committee, on the subject. It is being contemplated to make applicable to the personal guarantors of the corporate persons as well. The proposed cross-border framework has the potential to further strengthen India's insolvency laws. It will build capacity, empower the insolvency professionals and creditor to access assets outside India, trace avoidance transactions having cross-border implications, and achieve the core objects of value maximization as envisaged in IBC. With a rapidly transforming economy comes the need of the rapidly transforming institutions that supports its growth. Once enacted, the cross-border framework will provide a robust principle-based framework that Indian and the foreign stakeholder can invoke to restore cross-border insolvency situation swiftly in a more efficient and effective manner. Here actually there are some suggestions also. Now, what is the way forward? Adopting the unilateral model law should be the next step in strengthening its insolvency framework. This will include establishing rules for recognizing foreign proceedings and determining jurisdiction through COMI, defining relief measures for foreign creditors and representative, strengthening cooperation between domestic and foreign courts through formal protocols, conducting capacity building programs for all stakeholders to familiarize them with the new framework. In fact, the cross-border insolvency is no longer an option but is a necessity for a globally integrated economy like India. Implementing a robust framework will ensure predictability, fairness, and efficiency in resolving cross-border cases. It will also enhance India's position as a global hub for investment and business. Let us take a inspiration from Mahatma Gandhi words. Future depends on what we do in the present. By acting decisively now, India can lead the way in cross-border insolvency and set an example for other nations. I once again thanks entire IP team for organizing and discussing for organizing and discussing for their continued effort to advance insolvency practice in India. I hope that this team will continue to build a stronger and more efficient insolvency ecosystem which would throw light to the world. Yes,
Thank
with
you.
this work, I will convey my thanks. and good wishes. Hope this seminar will have a grand success. Thank you.
Thank you, sir. Thank you so much for your valuable knowledge sharings, excellent suggestions, and motivating speech for us as an IP team. We will obviously live up to your expectations. And now I request Ashish Makhija, sir, to express gratitude on behalf of IPNet and offer a momentum to our chief guest.
Okay, thanks, Tina. Friends, I think we must really appreciate the presence of Mr. S.B. Gautam. I think I know him, Mr. Gautam, for almost last 15 years, over 15 years. And when he was working as an official liquidator in the in Delhi, attached with the Delhi High Court in Ministry of Corporate Affairs, I was the standing counsel for the OL. I think we had a wonderful collaboration. The entire lawyer team, I think we worked wonderfully well, and a lot of results were produced under his guidance and the directions which were there. Friends, I think today has been a wonderful thing. He has spoken about cross-border insolvency, which is the need of the hour, which he has emphasized. And we have a very, you can say, able speaker today, wonderful speaker, Dr. Resham Garg. He will deliberate and expand on this subject. And if you have any questions, you can definitely ask. Sir, with whatever you see, the time which you have given it to us, we are very thankful to you. You have accepted our invitation for this today. So as a token of our regard and respect, we are offering you, we are showing on the screen the memento. So we request with the folded hands to accept it. We will send you the hard copy, the physical. Thank you so much.
Thank you. Thank you.
It was a pleasure to have you here, sir. Thank you.
Thank you.
And now we will, I'll hand over to Tina once again for introduction of the speaker and also a deliberation from our wonderful friend, Dr. Resham Garg. Thank you.
Thank you, our national head, our motivator, Dr. Ashish Makhija, sir. I would request Sandeep Chitkara ji to please introduce our speaker, Dr. Risham Garg.
Yeah, thank you so much. It is my honor to introduce our illustrious speaker, Dr. Risham Garg. So he serves as the Director of Center for Transnational Commercial Law, CTCL, at National Law University, Delhi, and also the Director of Center for Regulatory Studies, which is CRS. So Dr. Risham Garg is an accomplished legal academic and researcher specializing in insolvency, bankruptcy, and transnational commercial law. Dr. Risham Garg holds a doctorate of law, or I would say Doctor of Laws, LLD, doctoral research degree for his work on international contracts and the UNCISG convention. He presently teaches courses of transnational commercial laws, bankruptcy, insolvency, and restructuring, laws of contracts, sale of goods, private international law, and in the postgraduate and undergraduate law degree programs. He has previously taught papers of law of property, banking laws and negotiable instruments, international commercial arbitration, law of tort, and consumer protection, legal and constitutional history, jurisprudence, and legal methods. So this is actually a long list of accomplishments he has. Dr. Garg has extensive teaching and consultancy experience, having worked with institutions such as Delhi Judicial Academy, LBS NAA, Indian Society of International Law, and several national law universities. He has also collaborated closely with the Insolvency and Bankruptcy Board of India on consultancy projects and professional education initiatives. Notably, Dr. Garg has been instrumental in leading the insolvency and bankruptcy moot competition since 2017 and served as an academic consultant for the British High Commission and CII on cross-border insolvency projects in India. So overall, his areas of expertise include bankruptcy, insolvency and restructuring, arbitration, contracts management, and regulatory policies. So yeah, we have. So I'm pleased to actually introduce him. Over to Madam Tina.
Thank you, Sandeep ji. Thank you. for giving us details about our guest speaker. I would request Dr. Rishamgar for some keynote address on the topic. We all request him to give us some valuable insights of the topic. Dr. Rishamgar, we welcome you all. We welcome you from all of us IP. Sir, you are there? Hello?
Yes, I'm here. I hope I'm audible.
Yes, sir. Audible, audible.
Right. So, yeah, thank you, uh, IPNet. It was wonderful to listen to Honorable former member Shri MB Gautamji. And this is a very topical topic on cross-border insolvency that has been taken up by the IPNet. I would like to congratulate, first of all, the IPNet, Shri Makhija ji, and all the members to continuously and regularly organize such valuable sessions, which are actually very beneficial for the IP or anybody interested in the insolvency ecosystem. I am a, I consider myself as a student, as a researcher in business laws, commercial laws, and insolvency is a core part of the business law ecosystem. As uh, frequently Dr. Sahu used to say that uh, businesses are created, but there needs to be an exit. So when companies get a voluntary chance, they can enter into voluntary liquidation. But the BLRC also provides for two types of, stress. And when there is a stress, which is a business stress, then it's best to uh, liquidate. And in case of insolvency, we look for the resolution. So it's wonderful to have been listening and participating in the valuable IPNet sessions. And again, I would like to thank the IPNet organizers for having invited me for this very valuable session in which I would like to share uh, my some of the views on this. Let me see if I am able to share the screen.
So you can share the screen, sir.
Right. I should be able to do that. Okay.
So are you able to, see the share button?
Yes, I am. Are you able to see my screen?
No, sir.
No, sir.
Not yet. Okay. Just a minute.
Yes,
Now
sir. Now we can see your screen, sir.
Okay. So now my video is paused. Right. I hope, yeah,
Yeah, absolutely, sir. It's absolutely fine.
right. Okay. Okay. So let's try to demystify some of these concepts. What is cross-border insolvency and why there is no need to have any apprehension? So, the first interaction with the cross-border insolvency for any IP would be faced when the IP is appointed as the IP and you are to take control of the assets. So Section 19 provides the rights and some powers to the IP that you are to take over the uh, control of the assets, take over the possession, and make the list of the assets. So if the assets are in India, then it's good. That's not much problem. But if the assets are abroad, overseas asset, then it's a difficulty, So you can make a list if you are able to trace from the balance sheet, but then actually you have to go to that particular country and do some legal work so that those uh, assets can be, let's say, there can be a basically moratorium can be imposed. So when the insolvency application is admitted, insolvency is imposed, and though that NCLT order, that court order of moratorium, helps the insolvency professional or the IRP to go to the various locations wherever the asset is located and impose this moratorium order, show the moratorium order, and take over the control of the assets. And in case there are any legal proceedings, surface or any realization proceedings, then appropriate legal remedy in the courts can be initiated so that the realization or that further action can be stayed. Similar also is the expectation in overseas matters. So the difficulty is how to go for that. So IP does not need to actually uh, go into all of that function because there will be legal experts, the lawyers, the legal counsels who will do that. There is whatever the process is there, so they will do it. But this is the first step that you want, that this is an insolvency. Moratorium is an insolvency order, and it needs to be enforced abroad. Interestingly, in the previous discussion, Shri Gautamji all mentioned about two interesting cases, Jet and the Cell case. So these are, interestingly contrasting matters because if you look at Jet, the liquidation was admitted insolvency or liquidation because we have to understand that uh, in different countries the insolvency law operation is in a different way. In India, we follow a step-by-step process. That is, first the insolvency application is or the insolvency process is tried, the CIRP, and in case the CIRP is unsuccessful, then liquidation starts. But in several countries, directly a liquidation application can be filed. And this is what happened in case of JET. The operational creditors in Dutch, who were the Dutch operational creditors, they filed the liquidation application, and liquidation was admitted and ordered, and a liquidator was appointed who came to India with that liquidation order that, kindly recognize me as the liquidator for JET and kindly allow me to, do the needful. So this is exactly what you would want to do. But in NCLT in India, the situation was that India is not a party to the cross-border insolvency model law, and we do not have any cross-border insolvency. So at that stage, initial or request was refused. If we contrast it with the cell case, so there is no cross-border insolvency arrangement or agreement between India and US. There is no US requirement for a reciprocal arrangement for cross-border insolvency, but when the NCLT order went to US, they recognized it under principle of comity. So, some countries do that, so they have a cross-border insolvency ecosystem and they do not uh, look or they do not have the requirements of reciprocity. Had the US required a reciprocity requirement, then they would have turned down the cell request. So the US and several countries they do not recognize this need for a reciprocal arrangement. So these are some of the aspects that you can really realize and face when you look at these two or few leading cases. I will come to Videocon as well. But that is, some aspects which I wanted to initially start with before moving on to the theoretical aspects of cross-border insolvency. So I've just keep in mind the jet situation, and the cell situation. And then, we'll try to build up further on Videocon as well and some other cases as well. So, what is cross-border insolvency? Is a necessity to deal with insolvent debtors with assets across several jurisdictions. It aids with the insolvency process for Indian multinational with subsidiaries and assets in foreign jurisdictions undergoing insolvency process. And then key aspects essential to improved credit recovery rate, information exchange without delay, empowering insolvency representatives and remedy in foreign jurisdictions, and so on. Then, so what is the model law on cross-border insolvency? So Ancestral drafted this model law on cross-border insolvency to assist the states in relation to regulation of corporate insolvency and financial distress involving companies which have assets or creditors in more than one state. So in 2018 itself, the Ministry of Corporate Affairs released a draft chapter part Z on cross-border insolvency based on the ancestral model law. So when in 2016 the IBC was being drafted in the parliament, there was a discussion that there is a some omission in the IBC, and that is a chapter on cross-border insolvency. However, at that time, these two provisions, 234, 235, were introduced, and then it was mentioned that at a suitable time, a comprehensive cross-border insolvency regime will be introduced into the IBC. So the MCA was very clear that we will recognize and adopt the ancestral model law on cross-border insolvency, and the intention was clear within 2 years of enactment of the IBC itself. So the draft part Z is there, and the draft part Z basically means it's chapter part Z, means part of the IBC. So it will be an amendment to the IBC, it will not be a regulation. There are various reasons why India may choose to adopt the MLCBI: a desire to improve the legal framework for dealings with cross-border insolvency cases, projecting a positive, forward-looking, outward-facing, and progressive image. It may also influence foreign investment favorably for this purpose, which may improve the valuations in resolution plans, attract expertise and efficiency in the process. So there are, several benefits, and increasing the market. There's a big issue of the resolution plan values. The resolution plans are not giving, let's say high values or optimum values. We would like to have as close to the 70, 80, or 90%, or even 100% of resolution plan values where all the creditors can get nearly everything. However, the average is, close to 40 to 50%. In case the market is opened, the foreign investors, they need some incentive. So as the IBC is provides an exit to the businesses, similarly the cross-border insolvency framework provides the sentiment to the foreign, let's say, players, investment funds, that yes, they show the confidence in the legal system in India, and they can enter the market. They can also uh, they can use their funds and probably increase the valuation, increase the the resolution plans percentage. Now, what I want to also show you is that we need to understand this jargon. What is the model law? Then there are some ancestral convention, and how does the law work? So one of the best example of these ancestral instruments is the Ancestral Convention, which we recognize as the New York Convention on Recognition and Enforcement of Foreign Arbitral Awards. As in early as in 1940, we had the Early Arbitration Act, And when the New York Convention on Foreign Arbitration, that is recognition and enforcement of foreign arbitration awards, was enacted, it is a convention. So convention is like a law. Then India adopted it as the Foreign Awards Recognition and Enforcement Act of 1961. So this convention was adopted as a law in India as early as 1961. This was an arbitration. And in case of model law, so the ancestral model law in international commercial arbitration of 1985 was referred in India for the enacting of the Arbitration and Conciliation Act of 1996. So model law is a guidance to a country to frame its law. So you can tinker, you can take reference. However, convention is a law as it is. So it has to be adopted as it is, and there is uh, limited scope for tinkering with the convention. So convention is a law, model law is a suggestion. And that is again a very interesting reason why the cross-border insolvency was drafted as a model law and not as a convention, because there needs to be flexibility in the commercial laws. So the model law is designed to assist the states to equip their insolvency laws with a modern legal frameworks to more effectively address cross-border insolvency proceedings, and it concerns debtors experiences severe financial distress or insolvency. It focuses on authorizing and encouraging cooperation and encourage between jurisdictions rather than attempting the unification of substantive insolvency law, and respects the differences among national procedural law. So this is exactly the reason why the cross-border insolvency was drafted as a model law and not as a convention. So a loose definition or a realistic definition, a cross-border insolvency is one where the insolvent debtor has assets in more than one state, or where some of the creditors of the debtor are not from the state where the insolvency proceeding is taking place. So key provisions, principles are four: first, access; second, recognition; third, relief; fourth, cooperation and coordination. So it's just like, an IP expects from the court that you need an access, then there must be recognition of the IP representative, and then some relief must be awarded, interim relief, and whatever relief is required, various type of reliefs, and then cooperation and coordination of the courts and the legal insolvency professionals. Now, some of these provisions, some of these, slides I have taken, which is from the, so after the, this 2018 draft part Z, which was drafted by the MCA, then in 2021, they also came out with the rules and regulations, the cross-border insolvency rules and regulations. So the law, rules, regulations, nearly everything in draft form is complete from the MCA, from the IBBI. It is there, it is in the public domain. So the law is there, the draft law is there. It just needs to be implemented. So it's a good uh, point to try to read this type of a law. What is that law? So some of these slides I have taken, which is from those cross-border insolvency rules and regulations. Assuming it is implemented, then this is how the law is going to be, what are the requirements, what will be the compliances. So the code provides AA with the power to refusal to take any action for implementation, which in its opinion ought to be manifestly contrary to the public policy of India. So this is the exception on public policy. So in case there is a issue on related to public policy, then the NCLT uh, can reject that particular application to be recognized and enforced in India. This is the laws, these are all the provisions in that Part Z and the CBIR's cross-border insolvency rules and regulations. This is goes back to 6 years and 4 years now. A foreign representative has to apply to the adjudicating authority. Foreign representative shall be bound to follow the code of conduct as may be notified. An application pursuant to this part is made to the adjudicating authority by a foreign representative does not subject the IP or the foreign assets and affairs of the CD to the jurisdiction of courts in India or the adjudicating authority for any purpose than the application. So this is all clarified. Most of it is settled law in international domain, but it's still there so as to avoid any sort of confusion. Penalty provisions for the foreign IPs when any loss of amount or unlawful gain on behalf of the foreign representatives takes place. Applicability of the cross-border insolvency framework in India applicable to companies, body corporate LLP, not individual to individuals, not applicable to FSP unless specified noted. So this is as per the part, as per the IBC notified according to the CIR, which is the corporate insolvency only. Applicability of IBC to foreign companies and foreign LLP. Provisions of IBC to be made applicable to entities incorporated with limited liability under the laws of foreign country and having an establishment as defined in Part Z in India. Designated benches for adjudicating of cross-border matters. All the benches of an NCLT to be vested with jurisdiction to deal with applications under Part Z. And initially, the thought process was that only the principal bench must be vested with the jurisdiction in cross-border matters. But the difficulty was that there will be invariably some CD, some holdco, or some subsidiary which may have been in insolvency CRP across any NCLT in India. Then it would be difficult, some the let's say the or the subsidiary or the holdco or that particular company in India. In case of NCLT, the CRP is already going, but the foreign liquidator or the foreign IP who has control over the foreign assets comes to India for recognition and enforcement, and then that goes to the principal bench. So that would have been difficult. Hence, after deliberation, it was felt that all the NCLT benches must be vested with the jurisdiction on cross-border insolvency, and this will also enable all the benches to holistically develop their uh, global or cross-border insolvency practice. Then cross-border proceedings arising out of India, CD will be dealt with at the bench having jurisdiction over the location of registered office of the CD as per the existing NCLT rules. Insolvency proceedings pertaining to foreign companies to be dealt with by the principal bench of the NCLT only. Now, framework for access to and regulation of foreign IPs. Foreign IPs to be given access to insolvency system and infra in India for the purpose of cross-border insolvency proceedings. Foreign reps acting in cross-border insolvency proceedings in India to undergo a minimalistic authorization process with the insolvency board. A principle-based light touch code of conduct to be applied to foreign reps acting in cross-border insolvency proceedings. IBBI to be empowered to undertake investigation and so on. So neither the IBC nor the IP regulations restrict an IP from applying for accessing the insolvency system of a foreign jurisdiction. So uh, we can have some regulations in India for the foreign IPs, but every foreign company, foreign country will have their regulations for IPs. So in case a country maybe like US, which has no regulation or very minimal regulation for IPs from India wants to go to US, they would be subject to minimal regulation or next to none restrictions. Uh, right. Okay, so now there are some, very core aspects like determinant of the CD's COMI. Now, basically, the jurisdiction of NCLT is based upon the registered office of the company. Similarly, the jurisdiction to try a particular company must be based upon some criteria, and that criteria has been classified as COMI, center of main interest. So, center of main interest ordinarily means the registered office. However, the difficulty is in some situations, the registered office may be a like a post office address, pure post office address, or let's say the uh, tax havens where there is no asset. So in case, like we had situation like in some states of India, like, Bengal, Kolkata, where in some streets there were thousands of post office boxes, addresses of companies, which were letterbox companies without any assets. So the danger is in identifying the registered office only as the basis for jurisdiction is in case there is no asset, then what will happen? You can file an application in that country, but if there is no asset, there will be no interest in the city to defend it. They will not even defend. This has been the example. Hence, there needs to be some alternative measure where the jurisdiction can be vested and where the application can be filed. So that alternative is the center of main interest. So ordinarily, the center of main interest is registered office. However, in case the registered office it has no, control or no substantial assets, then at the seat of the directors or at the seat of the major control or the assets, that is the place where the COMI or the center of main interest must be located, and hence that is the reason why this COMI has been identified as the basis for the jurisdiction in international insolvency or cross-border insolvency. Now, taking an example with the JET case. JET case is very interesting, and most of us may not have been able to appreciate what actually happened. So, because the assets were located in Dutch, the aircraft of JET were located in Holland. Hence, the operational creditor was able to file the liquidation application in Holland that, these aircraft are here and I am a creditor. So kindly allow me to take possession and initiate the liquidation proceedings. So the court ordered, yes, okay, it is in our jurisdiction and let us start it. But when the fellow, so it is interesting why he came to India. Okay, so you should understand why the liquidator came to India. What was stopping him from selling off those planes in Dutch after the court liquidation order? Anyway, that is for another day. These are all litigation strategy. But we must understand that the Dutch liquidator came to India and filed the application for recognition and enforcement of the Dutch liquidations. So what was he asking? He was asking that he must be recognized as the liquidator, and he was also asking the Dutch liquidation proceedings to be recognized and enforced in India. And why was it so? It was so because the SBI failed in its efforts to file any insolvency application in India. So this is what is going to happen. Had SBI already filed insolvency application in India, despite so many such huge distress in JET, they were doing what not, they were trying lots of options, but there was no other options to other than starting insolvency. So had SBI already started insolvency in India, then the Dutch liquidation would not have started. So the Dutch liquidation proved a catalyst to SBI to initiate the Section 7 application. So when the NCLT rejected to recognize and enforce the Dutch liquidator's application, and that liquidator appealed to NCLAT, by the time the NCLAT heard upon this application of the Dutch liquidator, the appeal, by this time the SBI had already filed the Section 7 application. Hence, now the strategy changed. So now the situation is that NCLT has admitted NCLT has admitted JET to insolvency, And after this, now the appeal hearings are starting in the NCLAT. So now this is what happens when people, think about the consequences. So the JET had registered office in India, major offices, major assets were in India. And as per the principle of COMI, the insolvency or the main proceeding for JET ought to have been initiated in India only. So the JET, so the Dutch liquidator, did not contest. So in his appeal, he did not contest that main proceeding has started in Dutch. So, they could have contested that main proceeding is going on in Dutch. We will continue it and let us see what happens in India. No, there was no, they did not try this conflict. They knew that in India, the majority of the assets are located and the registered office is also located. So there is no point in contesting the Dutch liquidation order. So then willingly they made an application to the Dutch court to stay the liquidation order, and instead the India insolvency was taken as the main insolvency proceeding, which is not a very uh, consistent approach. I mean, which is not you that usually happens. This is a very good approach. This was a very positive approach which was taken by the Dutch liquidator, that they did not go into endless litigation at that stage. So just think, in India or in any place, the litigators, what is meaningless litigation and what is, meaningful way forward for resolution. So this is also a good inspiration. What should be actually done in these circumstances? So this is COMI, center of main interest, and I have just demonstrated where COMI would be relevant for as a registered office and where it will not be relevant as the registered office. So now the last line says presumption in favor of location of registered office has as the COMI will apply only if the registered office of the CD has not been moved to another country within the 3-month period immediately preceding the date of commencement of the foreign proceeding in such country. Now, most of these principles are based upon existing cases, the important case law. So there is a very important case law which in which the European Court of Justice has given this view that there must be some reasonable, there are companies which may want to shift their registered office just to avoid the insolvency proceedings. So you are all, chartered accountants, and you have always faced the situations in matters of tax planning versus tax evasion. So company may want to do their planning. Company may want to do their planning, but for the other respondent, uh, other company, it may be an evasion. You are trying to evade your liabilities, and that is why you want to uh, evade the process of law. So a reasonable period has been provided, which is 3 months. So if it is within 3 months, then we will consider it is we can introduce. So even if the registered office has shifted in the old registered office place, the main proceeding, the main insolvency proceeding can be started. So I'll just again explain to you. I've been discussing the main versus the non-main proceeding. So what is the meaning of non-main and main proceeding? So insolvency is a collective process. Collective process means that all the uh, creditors, all the assets are pooled together, and then at one place the insolvency as a collective process, judicial process takes place. So, and there is a moratorium, stay on all other actions. So it has to be at one place only. That is the basic meaning of the main proceeding. All others can be the non-main proceedings.
70 crore pata hai? 72 pata hai.
By one time OTS amount of 140 crores.
Ah.
Please mute yourself.
Tina, is it possible to mute everyone?
No, sir, I tried. That's
Okay,
why
no problem.
I asked them specifically
Sorry,
to
sir.
mute.
Please continue,
Please
sir.
continue, sir.
Okay, so just let me, move a few slides and then I'll take few questions. So, Vikram ji, please tell me, how much time I have. So accordingly, I
Uh,
will.
okay. So, sir, you can continue till 5:30, sir.
Okay. So what I will do is I will speak for another 10 minutes and then we'll see what questions we can
Yes,
have and
sir.
then another
Absolutely. That is
10
fine, sir.
minutes will, yeah.
That is fine. That is fine, sir.
So, now what I am taking is these are the draft law. This is the draft law which may, whenever it may be next year, it may be after 2 years, we never know. But this is actually the draft law which is there in the public domain. So rules on cross-border insolvency provides for the following, so this is already there. So these are most of these are from some cases. These are the discretionary reliefs in cross-border insolvency. If there is a foreign IP and they want some discretionary relief, these are the type of discretionary relief which may be provided. This is as per the law, draft law in India. So Jet, I have already explained to you. In the spirit of cooperation, the Dutch trustee aims to not take any decision under the Dutch proceedings that would adversely impact the interest of the company or the creditors in the event it becomes necessary for the Dutch trustee, in compliance with the Dutch bankruptcy code or any other court, or under any applicable law, to take any decision that might adversely impact the interest of the company or the creditors. The Dutch trustee shall give advance intimation of such decision to the RP. Right. Yes, no problem. My slides are there. My slides are with the IPCA, triple IPIs, ICSI everywhere. No problem. So applicability mostly related to companies, and I would not go into the theoretical much. So main proceedings are based upon common center of main interest, and non-main proceeding are based upon any place where the debtor has commercial establishments. So key concepts: foreign proceeding, foreign representative. So foreign proceeding means a collective judicial or administrative proceeding in a foreign country, including interim proceeding pursuant to a law. So this basically means that there must be a collective proceeding. So draft part Z, these are the various 31 clauses. Applicability of cross-border insolvency framework in India. So this is also the draft law, draft part Z, and the CBIRC, the cross-border insolvency rules and regulations, CBIRR. Kind of debtor Z should apply only to CDs, as the provision of IBC pertaining to individuals and partnership firm has not been notified except in the context of personal guarantors. Place of incorporation would apply to all entities incorporated with limited liability in India and in other foreign country. Kinds of business, ILC recommended that certain business may be exempted from liability, and so section, so you can read from the first section, the first section of the part Z. So first line itself says the purpose of this part is to incorporate the unsettled model law on cross-border insolvency in India so as to provide effective mechanism for dealing with cases of cross-border insolvency with the objective of cooperation between adjudicating authorities, resolution professionals, liquidators, CD, other stakeholders, and courts and other competent authorities for greater legal certainty for trade and investment. So again, the objective is very clear. For greater legal certainty for trade and investment. So insolvency is business and investment. So that is to provide the legal certainty. Then fair and efficient administration of cross-border insolvencies that protect the interest of all creditors and other interested persons, including the CD. Protection and maximization of the value of the CD assets, facilitation of the rescue of financially troubled business, thereby protecting investment and preserving the employment. Public policy exception. So there are some cases, but I will like to authorization, access to foreign representatives, center of main interest. Now I'll take one case study. This is very interesting case, although this is a European case, ECJ. But the interesting part of this case is that it is very realistic. And the benefit of the EU is that ECJ can, ECJ acts as an appellate court over the national commercial courts. So this is a dispute where parallel insolvency was going on in court in Italy for the same company and another in Ireland, and both were saying that we are continuing with the main insolvency collective proceedings, and both they were refusing to stay their process and recognize the other's insolvency process. So hence the ECJ had to decide, and ECJ, European Court of Justice, can decide that one court will, let's say, let's say, prevail in matters of the European law. So ECJ is an appellate court over the national courts in European Union. But in case of international law, in commercial matters, there is no international commercial court for these matters. So it gives a very good guidance how these matters may be considered in case, there's a dispute which is going on, let's say, between India and Singapore companies in India, Singapore company, India, UK, and so on. So this Eurofood was one company, and Eurofood was in SPV, actually, special purpose vehicle, and its holdco was Parmalat. Parmalat was the holdco Italian company. It incorporated Eurofood as an SPV in Ireland because Ireland is beneficial for tax matters like a tax haven, and Eurofood was incorporated to get funds, and those funds were utilized by Parmalat to for its business. It expanded its operations to South America, dairy business, and so on, and other businesses where those funds were invested. However, there were some issues. The business did not succeed. Business was uh, unsuccessful, and hence Eurofood came into distress and Eurofood came into insolvency. So the dispute is that Eurofood was registered in Ireland and its registered office was in Ireland. The banks gave loans to Eurofood in Ireland, and the banks started the insolvency procedure in Ireland. But the holdco Parmalat was registered in Italy. It was an Italian company, and the control of Eurofood was also in Italy, which was usually done by Parmalat. So Parmalat started the insolvency in Italy. So when the Irish liquidator came to Italy for recognition and enforcement of the Irish insolvency, the Italians refused. And similarly, when Italians went to Ireland, the Irish refused because the insolvency proceeding was already continuing. So both were saying that we are starting the main insolvency proceeding. So the dispute then was referred to the ECJ, European Court of Justice. And the European Court of Justice, discussed where is the COMI and which country will continue with this main proceeding only. So, although the Eurofood registered office was in Ireland, but uh, the company holdco was in Italy. Now, there are two things here. One is uh, where the insolvency proceeding has started prior in time. So, taking the example of Jet. In case of Jet, the liquidation started prior in time in Holland. and subsequently the SBI filed Section 7 application in India. So, in matters, let's say where, let's say both may have some, ground, in those situations, the rule of prior insolvency filing may be recognized. So, in some countries like US recognizes. So, in case, and several countries recognizes the prior filing in case concurrent proceedings are possible. In case, the COMI can be recognized in multiple places. So another, but the European Court of Justice also mentioned that in this case, even though Parmalat was the holdco and had started the proceedings, administrative proceedings prior in time in Italy, but they were not amounted to the insolvency proceeding. It was a temporary administrative order, and the insolvency proceeding started prior in time in Ireland, and the most strong argument was that Ireland was the registered office, the creditors gave loan in Ireland. Hence, uh, so there are, as I told you, rule of priority. Now, the criteria is required to be both objective and ascertainable by third parties, typically the debtor's main creditors. Now, this is also the statement. The criteria is required to be both objective and ascertainable by third parties, typically the debtor's main creditor. So, this is a guiding statement which is a guidance for the courts whether they must consider the expectations of the major creditors when they give the loan or the operational creditors also, because in some situations the courts have recognized the expectations of the creditors in case of banks when they have given loan, in case of the operational creditors when there is some amount due. So in those situations, basis the expectations of creditors, the COMI has been decided. So Ireland was considered to be the country of the COMI, and hence uh, the main insolvency proceeding were to continue only in Ireland. Now this case, Interdil versus Falimento Interdil, this is the case which I was mentioning, this 3 months time period. So Interdil SRL was a company in Italy, and on 8th July 2001, it transferred its register office to UK and removed itself from the Italian register. On 28th October 2003, Intesa petitioned the Italian courts to open bankruptcy proceedings. So this is approximately more than after 2 years. So after 2 years, the Italian company petitioned in the Italian court to open the insolvency proceeding. So there must be some reasonable time. So here the more than 2 years had passed. So in this case, the court, that is the UK court and the Italian court mentioned that a reasonable time would be 3 months. And in case the insolvency application is filed within 3 months of the company moving, then the previous home company courts would certainly have the jurisdiction to uh, start the mid-insolvency proceeding basis the registered office. So this same 3 months period, and this case has been referred to in our CBIRR, which I have just shown to you. Okay, so this is a case like a group insolvency. Daisy Tech 2003. Daisy Tech parent company defaulted on financial covenants, and this default caused financial problems for the subsidiaries in Europe. Consequently, insolvency proceedings were filed in US, England, Germany, and France. And in light of the case, English court was satisfied that COMI of each company in the group was situated in England, specifically in Bradford. So because this Bradford office was the coordinator and the performer of the European group, which included the negotiation of the supply contracts. So let me now take some of the Let me see the questions.
You are done with your presentation, sir?
No, presentation is still continuing. Do you want me to complete it?
I think, sir, if you take another 5-7 minutes to complete, then we have a lot of questions on the subject. We can
Okay.
actually take up all the questions once you complete it.
So let me take one case. This is interesting case. This is a cross-border litigation. So cross-border litigation, what happens in uh, cross-border litigation. So there is a, let's say, a money suit, and in this, what is this case is Sumikin Busan. Sumikin Busan is a Hong Kong company, and it was against this company which is Kingshing Enterprises. So Kingshing Enterprises, the owner was Manhar Lal. Manhar Lal was resident of Singapore, but originally belongs to India. So Kingshing Enter
All the participants are requested to kindly mute.
Kingshing Enterprises had some contract in Hong Kong with Sumikin Busan, and there was some dispute, and Sumikin Busan won that case and became the judgment creditor. So what will the judgment creditor do? So judgment creditor will enforce the decree against the property of the judgment debtor. So wherever the judgment debtor is. So this is, what you most of the CAs, some also do like asset tracing. You will look into the balance sheet, you will look where are the assets, and the judgment execution decree will be taken at that place for execution. The same happens in case of the arbitration also. So this Kingshing Enterprises did not have any material property in Hong Kong, so they went. So the judgment creditor Sumikin Busan went to Singapore, and then Manhar Lal had some property in India, in Bombay also, and went to Bombay also to execute that decree. So what happened that this, interestingly, this also tells you how the CPC provides for recognition and enforcement. So we were considering recognition and enforcement of this jet in case of cross-border insolvency, which is not there, but we have a system of cross-border litigation, which is the recognition and enforcement of foreign judgments and orders and decrees, which is in CPC. So CPC under section 13, 14, and 44A provides for the recognition and enforcement of the foreign judgments and orders, just like we have this. I mentioned to you the New York Convention on Recognition and Enforcement of the Foreign Arbitration Awards. So 44A is different from section 13, 14 of the CPC. That 44A provides for the direct execution, but in case of section 13, 14, there is a requirement of the decree has to be registered with the court, and then the court will look into whether it is proper, and the like a trial will continue, and only after the court is satisfied, then it will issue the decree. However, in case of 44A, 44A provides the recognizes units like the similar to that New York Convention on Recognition and Enforcement of Foreign Arbitration Awards, in the sense that there are notified countries under the schedule of CPC, and if there is an order from the superior court of those countries, then it will be directly recognized and enforced in India. So Hong Kong is not a reciprocating territory within Section 44A of the CPC, and hence then the regular application was filed under Section 13 and 14, and the court found that the decree is okay and passed the execution decree. So when this execution decree was passed by the court in Bombay, and the property of Manhar Lal was attached in Bombay. Now, during this time, the Manhar Lal had filed his self bankruptcy application in Singapore. So whenever there is a, the benefit, as you have seen in case of personal guarantors, so you have been facing these issues that there is a Section 7 application against a CD, and then the guarantors file their bankruptcy application also, which there is an interim stay, immediate moratorium versus the Section 14 moratorium. So in case of the self bankruptcy, there is a immediate interim moratorium. So no property can be realized till the bankruptcy is resolved. So when this bankruptcy was admitted of Manohar Lal in Singapore, there is a stay order, and then he also, brought this stay order to Bombay High Court, to Bombay, that, I have received a bankruptcy stay order, and I want you to recognize and enforce and stay the execution proceedings against my property. So the Bombay High Court in that case mentioned that the execution proceeding were already underway, and at this stage they cannot they cannot consider the Singapore bankruptcy stay order. So, but this is a very interesting case how the cross-border litigation takes place and can take place. Okay, so let me just quickly come on to the group insolvency matter. So in Videocon, there was a consortium of banks led by the SBI moved an application for substantial consolidation for the 15 companies belonging to the Videocon group, where the consortium was the common creditor. Separate CIRP petitions were admitted against all the entities, but the processes failed to obtain any attractive bid because of the lack of collateral assets and their inability to survive individually. In the absence of any prevailing provision in the legislation using its sovereign jurisdiction, Honorable NCLT Mumbai analyzed bankruptcy jurisprudence in the US and UK and decided in favor of consortium by admitting the petition of consolidation of 13 entities out of 16. 13 out of 15, sorry. So test for consolidation, primary test the 13 parameters approach. NCLT offered a two-step test to consolidate the assets and liabilities of the CD. And these were 14 factors like common control, common directors, common assets, common liabilities, interdependence, interlacing of finance, pooling of resources, coexistence for survival, intricate link of subsidiaries, intertwined accounts, interlooping of debts, singleness of economic units, common financial creditors, and common group of corporate debtors. So these 14 tests were factors were identified by the NCLT Mumbai to consolidate these Videocon companies, 13. And then step 2, test for self-independence. So two companies, Scale and Trend, were self-independent, and they were kept outside this consolidation. So now this consolidation, this consolidation in case of Videocon was a procedural consolidation, procedural to enable the resolution plan as against a substantive consolidation. A substantive consolidation is when now they have to debate, the Videocon resolution has failed. I mean, it has nearly failed. So we'll see, what will happen. So it's still uh, to be seen that what will happen to the Videocon insolvency. So the group insolvency was ordered, there were resolution plan, but more or less it is unsuccessful now. The resolution process is implementation committee. It's not being implemented. So, assuming it goes for liquidation, so let us see how the uh, liquidation will be, So, substantive consolidation could be in case all those assets will be pulled together and realized, or the liquidation will be ordered, or the separate units will be ordered in liquidation. So, but the CBIRC 2 on group insolvency has takes a different approach. So the consolidation can only take place after all the individual units are into insolvency, and the COC, the IP, they mm, agree, move a resolution that they want to consolidate for a procedural consolidation, which enables the synergies of resources. But still, the CBIRC 2 on group insolvency still says that the resolution plans will be individual for all individual companies, but there will be one group RP also. So there the individual CIRPs will continue, individual resolution plans will be invited, individual resolution plans will be considered and approved or rejected, but there will be a group coordinator for the for the group insolvency. So this is the proposed ZA. Then there is a judicial insolvency network. So there is a network of the judges, which is led by Singapore insolvency judges, and insolvency judges for India have been regularly participating in that judicial insolvency network. So like the IPs collaborate, similarly the judiciary also collaborates, and there is a network which helps in the coordination. So before 2013, 1956, the insolvency, there was no insolvency, but there was one provision that in case the company is unable to pay its debt, it can be wound up. And companies that are not registered in India under Section 584 could be wound up under certain circumstances. So this was one case, Raja Vizianagaram versus official liquidator, where this company was based in UK, but the assets were in India, and there were several creditors which were from UK, and the creditors from India, their suggestion or their argument was that the British creditors should not get anything. But the Supreme Court held that no. I mean, at that time there was no cross-border insolvency, so there was a protocol. At that time, in this case, Raja Vizianagaram also a protocol was created for court for this in creditors cooperation, and the Supreme Court held that the British creditors or the foreign creditors also have a right as creditors to the assets of the debtor company. So the debtor company, the Vizianagaram estate was a huge estate. They were able to pay all the creditors 100%, and after that, still a lot of money was remaining. And as per the company law uh, jurisprudence, settled jurisprudence, that creditors can get 100%, but not a paisa more. So whatever remains remaining will go to the shareholders. So when 100% of whatever was due to the creditors, India, foreign, all was paid, and whatever was remaining, which was still very substantial, was given to the distributed to the shareholders. So the Insolvency and Bankruptcy Rules 2020 and Part Z incorporates ancestral model law on cross-border insolvency, and Part ZA draft group insolvency under the IBC. So these are two parts suggested of the IBC. Right. So that will be all from my side.
Thank you, Dr. Risham Garg, for knowledge sharing. Now, I would request Mr. Vikram Kumar, member of National Executive Committee and Regional Head of IPNet North, to express gratitude on behalf of IPNet. And I request IP Parag Singhal, General Secretary IPNet, to offer a momentum to our speaker, Dr. Risham Garg.
So, sir, we are very grateful, Dr. Garg, for your very insightful, session. We are receiving a lot of questions on the cross-border insolvency. So let's see, how many questions we can take. So, without further ado, I would like to quickly, get on to the question and answer. So what I would request in Parag is, he can offer the memento. It is also important to mention that Dr. Risham Garg is also a member of the National Executive. So, he's not only a guest, he's very, very much a part of the IPNet fraternity. So, Parag, I would request you to kindly, offer the memento, Dr. Garg.
Thank you, Dr. Garg, for taking out time and sharing your knowledge base with us. It was a wonderful session.
Thank you. Thank you for inviting me. And I just hope that this session was informative for all the members.
Yes, sir. Very, very informative, very, very knowledgeable, sir. Thank you, sir.
Vikramji, you can have questions now.
Yes, sir. So basically, sir, to begin with, I see there are a lot of questions in the chat box because I'll tell you the primary issue is that domestic insolvency itself is very complex. Because IPs are struggling to handle domestic insolvency. If you add the twist to cross-border, the challenge is that if suppose the assets are located outside and the IP is located in India, how can he take charge of the assets outside India? That is one set of question. Or if the debtors are situated outside India, or so if I ask you with reference to Jet Airways, like what was stopping the liquidator from Dutch to start the proceedings in Dutch without actually coming to India? What was it stopping him to start the proceedings? What was the need to actually come to India and take a permission? So these are the basics of questions. I think you can start with the basic question, and then we'll go to the specifics, sir.
Yeah, when I was mentioning Jet, I specifically said that I do not want to think and attempt to respond to this aspect why the Dutch liquidator came to India.
Yeah.
And but I still mentioned that this is also the objective of IBC, that we must positively look towards the resolution rather than meaningless litigation. So when you are all IPs, you're all chartered accountants, you're all business people. This is a business decision. And the business decision is that there are two aircraft. At that time, there were two aircraft in Holland, which were worth millions of dollars, whereas the claim of those operational creditors were hardly 20% of that value. So, when you go for SARFAESI proceedings, the question I will ask you is, if you have to realize an asset, will you go for SARFAESI proceedings or will you go for insolvency proceedings? And how will you decide? How will you choose whether you want to go for the SARFAESI proceedings or you want to go for the insolvency proceeding? So the question in this case was that the money is there, 20% to 25% is to be received by the Dutch operational creditors. What will they do for the remaining 70% money? And for that, they came to India that this is liquidation, this is not realization. In liquidation, it is collective. So all the claimants have to be brought together. And it is our responsibility, it is your responsibility as a liquidator to consider all the stakeholders and distribute the proceedings amongst the distributors. This is the reason the Dutch liquidator came to India, or any liquidator will go to any country to fulfill their ethical obligations.
Sir, thank you, sir. So basically, sir, I would just like to, understand on behalf of all the IP fraternity, if a IP is handling a CIRP in India, and if some of the assets are located outside, how to handle this situation, how to take charge of the assets located outside, what would is the best way forward is something, we would like to understand.
See, the thing is that I have gained my knowledge and experience in interacting with the IP community, in the interaction with the professionals, because the law is there, but law is limited, and the legal, let's say, are limited. Let's say the CPC. So CPC schedule, uh, which provides for the recognition and enforcement in those countries on a reciprocal basis. Apart from that, CPC provides under Section 1314. So you have to look into every country's similar provisions for recognition and enforcement of the foreign orders. Now the problem is that although filing a civil suit. So Section 1314 of CPC is like filing a civil suit. It may take whatever time, you don't know, 2 year, 3 year, 4 year, you never know, and there may be an appeal also. So it is not relevant for this interim process, for taking control of the asset. Because if you want to enforce the stay order, which has to mediate 1 to 3 months, but if there is a civil matter which may take 2 years, nobody is going to try the civil proceeding to enforce the stay order or moratorium, right? So hence there needs to be some bilateral arrangements.
Right, sir.
Now, uh, I know that in some matters, for example, Videocon, and in some other matters, some IPs and some experts tried to go to some countries. Let's say the assets, the CD is, registered in India, CIRP is in India, but assets are located abroad, UAE, Africa. In case of Videocon, the assets were in Brazil, Indonesia, and so on. So, in case where let's say Indian Oil is a party, Indian Oil is into a joint venture with that particular country, then it's slightly simple, they will have some teeth in the game. But in countries like, Africa, Uganda, and some other countries where there is no cross-border insolvency framework, or we have just been reading about this business, Oswald business problem in Africa. So the problem is that in some of these places, the local creditors will be given preference. So it's going to be very difficult. So it's a case-to-case basis, and that is why the government needs to enable, that infrastructure, how in those places these insolvency orders for stay can be implemented.
Right.
And
So what we can do, sir, thank you very much. So what we can do, we can first take up the questions on the chat box, and then we can open the house if somebody has any questions to ask. So I'll go to the chat box. The first question I can read is from Mr. Hari Prasad. So he is asking, can an IP registered with IBBI be an IP in the following cases? He has given three scenarios, that the CD is registered in a foreign country and the creditors are registered in India, are in India. So basically, sir is trying to ask whether, an IP who is registered with IBBI can be a IP for a company situated outside the country.
so even in my PPT, I have written this. It is very clear that if you want to be an IP in a foreign country, IBBI has no jurisdiction, and IBBI has clarified. Dr. Sahu has clarified. We are not bothered. Our jurisdiction does not extend to another country. If you want to take up an assignment as an IP in a foreign country, then it will be as per that country's norms.
But sir, I was referring to your presentation. Somewhere you had mentioned, so the question which arose is Can suppose there is a foreign IP who is operating in India, can he be regulated by IBPI?
If no, so again, the
Say the
thing
commie
is,
is situated outside and there are some assets in India. Now he's also, doing some work of the insolvency in India. So can he be regulated by IBPI with respect to the proceedings continuing in the country?
so so we have to look into the guidance provided by the case of Jet, where there is a protocol. So whenever formally a foreign IP wants, let's say, assistance of the court, then there should be some protocol basis the JET protocol for cooperation and coordination. And otherwise, there may be experts who may be informally, supporting, but they must be then as per the norms. So, this can be case to case basis, but I don't think there is any difficulty to understand. If you want to catch hold of a person, well, you are free, you can do what you want. So the answer is very clear that in case a formal process is to continue, then the JET protocol has to be undertaken. Otherwise, informally, whatever they are doing, if it is legally valid, if it is not illegal, then let them continue. If it is has to be under the regulatory purview, then it has to be brought out within the regulatory purview.
Right, sir. So the next question is from Sandeep Chitkara. He's asking, sir, what if there are no simultaneous commencement of insolvency proceedings in all the jurisdictions of the CD? Can an RP in India get access to the assets of the CD in foreign country? Is something actually we have already discussed, but still, sir, I think that is the main contention which most of the IPs are having, sir. Would you like to add anything, sir? Or I think you have already answered in great details on this subject.
So I think we have already discussed. It's
Yes,
see,
sir.
the thing is that I don't want to give any legal advice because
Right.
there are lots of facts, and basis the facts, the legal experts will take a decision. But the problem, you are very right. The problem is, even we are facing in uh, there are now demands to open up the, let's say, the Amtech matter, because there were foreign assets and they could have been introduced, they could have been realized, and so on, or avoidance applications, so on and so on. So there are several things that matter, and the policymakers have to consider a lot of aspects. So whatever is possible, the IPs and the legal experts will look into. There is no law as such. If there is
Right.
a law, then things get smooth. If there is no, let's say, consistent law, then you have to find the solutions
So, sir,
on a case-to-case basis.
Mr. Chitkara is also asking, will an order of NCLT in India be recognized by foreign jurisdictions?
So I think he has not been able to listen to what I was saying. The first sentence that I said was on JET and CEL. And CEL is an example, which is an NCLT order of NCLT Chandigarh, which was recognized by the US Bankruptcy Court, despite there being no cross-border insolvency arrangement with India.
Okay.
It depends upon country to country. They may not. India did not recognize the JET order, but US has recognized the NCLT Chandigarh order
So it's a
on
case
CEL.
to case basis, sir, basically, right?
It depends upon country to country also.
Country to country. So, sir,
Hmm.
these are the questions on the chat box. If in case now we can open the house, if anybody has any question, he can raise his hand, and we can take up the questions. Otherwise, I have a few questions, sir. I can take it up, but let us see,
Please, sure.
if we have
Yeah.
any, in the participants, if they have any question, so we can take up those questions first, sir. So I think, if anybody has any question, you can kindly unmute yourself, switch on your video and ask the question directly from Dr. Garg.
No, I mean, anything, you are most welcome. Yes, this is, you are all, so we learn, we gain by experience, we gain by interaction. I will also learn from your cases, what cases you are facing.
One
And
sorry. Please, sir, continue.
no, I was just saying I have really gained a lot in my interactions with the community of IPs in my, interaction with the triple IPI, the ICSI, IPA, and the cost accountants. So all these three institutes, I have really gained a lot of knowledge and experience.
So anybody has any questions, sir, to ask?
So
Yeah,
we are facing a
may
very
I
peculiar.
ask something?
Yeah,
Gupta,
please,
may I
please,
ask
please. Parag.
So like Garg sir, like you said that in the case of Videocon, certain tests were applied, like 14 tests were applied, and like interlacing and intermingling of the assets and so on and so forth. So those tests were applied, and 15 out of 13 companies were grouped together. But somehow, the liquidator or the RP might have tried to. Uh, so those were grouped together, and the RP or the liquidator might have tried to actually sell those assets as a group. But somehow that actually, I would say, that test or that thing failed eventually. So. So how can actually, like, if 14 tests have been recognized, and those if those are applied to other cases as well, so what do you think will be the result out of the same? So why the Videocon test failed, and how can this be implemented to maybe other cases? So wherein there might be assets in various countries, and by applying those tests, those assets can be grouped together, and those can be sold.
Yeah, so ultimately, this is the best example of group insolvency these days is going into real estate, and Videocon was there. But the best examples and the most complex structures in groups are in real estate. And the issues are that there is a company who does not own the land but is entering into contracts to sell property, contract to sell agreement, contract or sale agreements with the buyers. And buyers have entered into contracts with companies who do not have the asset, and the companies who have the asset, it's a company, but they're all related companies. And these companies who own the asset, they have mortgaged with the banks. And then we have these situations of the uh, in case of real estate, there is a project-wise resolution, there is a reverse CIRP. There are complex situations which are being faced. So, again, in case of group insolvency, you have to look into the case-to-case basis. And the Videocon example was there. It could have been done just only because SBI was the lead consortium banker. And
Okay.
this sort of a situation is nearly impossible. It's like a perfect situation. It is nearly impossible to find where there is one lead banker who will take the initiative. SBI did take the initiative to consolidate. It was good. However, the Videocon problems, so there were numerous. Even though Videocon was a good white goods company, but there were PMLA, there were lots of issues because of which the the resolution plan was not successful. I mean, it is still, we should not say it is not successful because the final outcome is not, it is still sub judice, but it appears to be going the jet way only. But yes, this is the as I understand, can be two learnings. One is in case there is a lead banker or a consortium banker like SBI who can move forward with this consolidation, it is possible. But now there are next to none. And in case the CBIRC2, that is the Group Insolvency Part ZA draft, it discards this approach which was adopted in Videocon because it says that all the companies must be in CIRP and all the individual companies' resolution plan will be independent only. There will be no group resolution, one resolution plan. So this Videocon approach has been discarded in the Part ZA itself.
So you
Okay,
also
sir. Thank you
in
very
this
much.
very
So I
case,
think, we have Mr. Srinivas who has raised his hand. Yeah, Mr. Srinivas, you can ask your question.
Good evening, sir. Session is very insightful and knowledgeable, sir. So my question is, sir, presently I am handling one liquidation assignment, sir. My company is a subsidiary of a company in Singapore, sir. That is a 100% subsidiary of Comi in India itself. And company in Singapore has 75 million, sir, in its assets. Unfortunately, this my holding company is having 5 another subsidiary companies in various locations across various countries. So this holding company, which is Comi, has also undergone this CIRP process. So the successful resolution applicant has gained the thing, and he is uh, taking all the assets, making it as a zero, and taking over all the assets of the foreign company. How can I, first of all, stop these proceedings, sir? Or how can I get my money from this 75 million to fund my subsidiary companies? Where should I start proceedings? From where I should
So,
start?
this is a classic case, and every company is a separate legal entity. So, the tests which were adopted in Videocon, like commingling of
They
assets and
are
so
taking
on,
shelter of this corporate view, sir. This is the